Thank you, Mr. Chairman. First point, the Republicans demanded a special counsel in the Biden case. The Republicans demanded a special counsel to look into Trump because they said that the Attorney General couldn't be trusted. So the special counsel was a demand on the Republican side. In any event, just to get back to the heart of this matter in terms of the law, Professor Besky, you point out that the Supreme Court rendered this unanimous decision in Mesa versus California, establishing that there needs to be a federal question defense in order to remove from state court to federal court. And the burden of your testimony is to say that even if this bill were passed that our colleagues are proposing, it wouldn't alter that in any way because you can't overturn a constitutional ruling with a mere statute. So would there in fact be this intended effect of being of allowing Donald Trump and all of his associates to be removed from state court prosecutions, even if there's no independent federal question defense?
Sorry, no, and I think it's really important to flag that Mesa considered and specifically rejected the United States argument in that case that federal officers can remove simply because they hold a federal office or simply because the suit charges conduct under color of that office. That was specifically the United States argument, and Justice O'Connor specifically rejected.
I mean, that would be like creating a title of nobility. If you hold a federal office, whether it's elective or appointive, you can never be charged under state law for murder, rape, armed robbery, theft, fraud, whatever it might be. It's just amazing to me that our colleagues would make such an argument that's so breathtakingly anti-federalism that the states are just drained of all sovereignty over the common law crimes that would take place within their state. So if you're right, and I believe that Mr. Terwilliger just conceded that you were, I wonder what you think about his suggestion as a way to repair their bill to simply say that there must be federal question jurisdiction, but that just is tautological. That just restates what the Supreme Court's already found, right?
Well, I think what he's saying is it's enough that the statute says he's operating under color of his office, and that should satisfy Mesa.
But that runs into the supremacy clause fallacy that you pointed out originally.
That's the argument that Mesa rejected. Mesa said that's not enough. That does not satisfy the requisite federal ingredient necessary under Article 3, necessary to satisfy the Constitution. So that argument is a non-starter. They have rejected that unanimously.
So what this really adds up to is some people complaining about the fact that Georgia law enforcement authorities and New York law enforcement authorities operating independently as states within the sovereignty they've got without any actual evidence that Joe Biden or Joe Biden's Department of Justice had anything to do with it, decided to prosecute people for crimes committed under their laws. And they don't like the fact that they weren't able to remove to federal court where they felt that they had a more receptive audience because Donald Trump had appointed a lot of the judges, right? So what is there actually to do? The Supreme Court has rendered its decision in the matter, right?
It has, and one thing I always teach my civil procedure students is when someone attempts to remove, it's as if you pull a lever. It automatically goes to the federal court, and it's the federal court that makes the call as to whether removal is or is not a good thing. And so Helverson is a federal judge. It is Helverson that made the call as to whether the requisites of the federal removal statute were satisfied.
In the Mark Meadows case, you're saying?
No,
in the Mesa
Helverson
case.
Is in the Southern District of New York. Helverstein, I'm sorry. He is the person that made the call as to whether it was under color of the office and whether there was a colorable.
So you're saying it was a federal court ruling on the question of removability.
Correct.
So that would be the same also in Meadows' case and in the Mesa case. All of them go to federal court, and what you have is federal judges saying with the Supreme Court backing them up, this doesn't belong in federal court.
Correct.
This is a run-of-the-mill state criminal law prosecution.
Correct. It's not under color of office, and there's no colorable federal defense.
And our colleagues want to turn a federal case turn it into a federal case because Donald Trump doesn't like it. And with that, I'll yield back to you, Mr. Chairman.
Now I recognize the gentlelady from Wyoming, 5 minutes.
Thank you. Ms. Foley, can you describe for us what lawfare is?
Lawfare is the use of legal processes, either civil or criminal,